All rise. A very good afternoon to one and all present here. Before we go ahead with the inauguration function, let us invoke the Almighty's blessings. I now call upon Varsha Raghavan to render the invocation song.
मैत्री भजत किल हृजयति आत्मवदेव परानपि पश्यत आत्मवदेव परानपि पश्यत युद्धं त्यजत स्पर्धां त्यजत युद्धं त्यजत स्पर्धां त्यजत त्यजत परेष्वक्रममाक्रमणं त्यजत परेष्वक्रममाक्रमणं मैत्रीं भजत किल हृजयति मैत्रीं भजत किल हृजयति जननी पृथ्वी कामदुगास्ते जननी पृथ्वी कामदुगास्ते जनको देवा सकल दयालु जनको देवा सकल दयालु धाम्यथ धत्त धयत्वं जनता धाम्यथ धत्त धयत्वं जनता श्रेयो भूयात् सकलजनानां श्रेयो भूयात् सकलजनानां श्रेयो भूयात् सकलजनानां श्रेयो भूयात् सकलजनानां श्रेयो भूयात् सकलजनानां
It's my pleasure to invite Dean Planning and Development, Dr. S. Subramanium, to deliver the welcome address.
Very distinguished scholar speaker for this 11th NANI Palkhivala Memorial Lecture, and also the chief guest to inaugurate the 11th NANI Palkhivala Tax Moot, and the first time that it is happening here at Shastra University. Faculty colleagues, special invitees, student friends from various law schools who have come here to participate in this prestigious moot. And I'm sure you all know how fortunate you are that you are also going to listen to a scholar speaker delivering the NANI Palkhivala Memorial Lecture. And my own student friends, ladies and gentlemen, as usual, I'm extremely happy to share the dais once again on this momentous occasion. And it's been customary that I've been delivering the welcome address for the previous 10 NANI Palkhivala Memorial Lectures that have been given here at Shastra University. I must confess today I'm a little tensed because I've been given a very difficult task to talk on three things: on two extraordinary people, and on one extraordinary issue on which I absolutely have no knowledge at all. And all the three in the shortest possible time. So that's the biggest challenge. But I will assure that the organizers have not made a compromise in choosing me to deliver the welcome address, also lay down the context for the Palkhivala Memorial Lecture. You see, our association with the legendary jurist Nani Palkhivala goes years back when we actually invited the great man during the early 90s to come and deliver a convocation day address in our university. And those were the times that the Air India was known, or Indian Airlines at that point of time was notorious for its punctuality. And the person that Nani Palkhivala was, a man who valued time so much, that was the only single reason. I still remember the words that he used. I don't want young students to wait for me because they are all excited to receive the degree, and I don't want a delay in the Indian Airlines aircraft to stand between them and the degree. And of course, we didn't have an opportunity after that to have him on campus. And after the unfortunate demise of the great man, we then decided that we will, every year, even when we did not have a law school at that point of time, conduct the Nani Palkhivala Memorial Lecture. Because who can forget the great contribution that the man has made, about which I'm sure the speaker today is going to talk enough, who protected the basic structure of our constitution. And when I heard from one of my students that the GLC Mumbai is not interested in conducting the Nani Palkhivala tax moot, I thought there is another opportunity that is presenting before me. I immediately contacted Mr. Berham Palkhivala, the brother of Mr. Nani, and told him that this institution has a very special relationship with Nani Palkhivala. In fact, sir, for the benefit of the speaker, every year when the students join here, we give them a copy of the Courtroom Genius, a free copy to the students, because this generation needs to know what a great man Nani Palkhivala was. And such a great man must be a single largest source of inspiration for all the students of the law school. And when I made this request to Mr. Berham Palkhivala, he didn't know where Shastra University was. And then I told him the type of work that we are doing. He said he was so happy, and the Memorial Trust in its meeting finally decided that Shastra University School of Law henceforth will be hosting the prestigious Nani Palkhivala National Tax Moot from this year onwards. And I take this opportunity to thank the Memorial Trust on all of our behalf for having given us this wonderful opportunity to conduct this prestigious tax moot in the name of the legendary jurist Nani Palkhivala. And we continue our tradition of inviting some of the best scholars to deliver the Nani Palkhivala Memorial Lecture. Continuing with this tradition, we have with us, ladies and gentlemen, this afternoon, a speaker, a scholar speaker, as I told you before, a speaker who is a manifestation of multidimensional intelligence, one part of which I was an immediate witness just half an hour before when he was addressing a different audience. Everyone knows that he is a great advocate, known for his advocacy skills. You know that he has been a part of various committees of the Supreme Courts and other statutory bodies. He has represented various cases, landmark cases. All of this, all of you as students of law, you know. I'm not going to share those details that you already know with you. But I would like to just share 3 instances, experiences, or 3 things that I came to know of him, one of which was my personal experience, and the others when I watched a lot of videos and interviews that I usually do, which I think I must share in this audience, because that will show the man that is going to address delivering the 11th Nani Palkhivala Memorial Lecture here. One thing that I want to share with the audience here is the speaker is a man who wanted to honor the promise that he made to his mother that he should become a lawyer, because it was not one of his chosen profession in his formative years. A man who wanted to be a poet, a man who wanted to get into the field of literature. In fact, he used to say in his own words that he was so impressed the way in which Brian Johnston used to deliver his commentary, cricket commentary for BBC, that he also wanted to become a cricket commentator. the cricket's world loss is the legal world's gain. So here is a man who wanted to honor the promise that he made to his mother as a dutiful son and chose not to ignore but not to engage as a serious profession, something that was very close to his heart. And the second thing, that I am an immediate consumer by experience. A few years back, I was in the Madras High Court. I was going around the bust of the famous Justice Muthuswamy Iyer. And the speaker was talking to senior advocate Shri Panchu, if I remember. And I was just going around the bust. And then after I went around it thrice, he called me. He told me, I don't see you in the black robes, nor do you look like a court officer here. And why is that you're going around this bust? I told him that, you see, I am not a lawyer, I am not a court officer, but I am a litigant right from 1984. And just as most of the lawyers go around this bust with the confidence that justice will be delivered in the right spirit, I as a litigant also have the same confidence, and that is why whenever I get into the court, I make it an opportunity to go around the bust of Justice Muthuswamy Iyer, even before I enter into the court hall. But not many senior advocates would call somebody whom they do not know at all and inquire as to why I'm doing this. I'm talking out of personal experience. In Supreme Court, I don't want to name. In one of the cases which involves the university also, but it was a group matter, a batch matter, a senior advocate appearing for somebody else was arguing, and during lunch break I made an attempt to tell him that probably that this issue should be handled in a different way. He did accept what I was saying was right, but he said to me, look, gentlemen, if you want to tell me that I am wrong, please tell it through my junior, not straightly to me. But here is a person who doesn't believe in that. In fact, I shared this incident with my students. The students came and told me, sir, you're right. Because 2 years back when we went to the court visit in Supreme Court, we were all standing in the Supreme Court. Mr. Gopal Subramanium voluntarily interacted with our law school students, inquiring where are you from, and that's the way he nurtures young minds that get into the legal profession. In fact, in one of the interviews he said, one of the hallmarks of a senior advocate is to nurture the positive energy, enthusiasm and the commitment that the present generation of junior advocates bring to the profession. Here is a person who always believes that this young generation that's getting into the legal profession needs to be nurtured with the right spirit. And the third issue above all is the faith that he has in the spiritual, cultural and the civilizational assets of our country. And all these three put together has manifested, as I told you before, a person with true multidimensional intelligence. And whenever I deliver the welcome address for the NANI Palkhivala memorial lecture, I make it a point to mention that Mr. P.C. Alexander once mentioned that NANI Palkhivala was the best finance minister that India never had. And in the same way, in my opinion, Mr. Gopal Subramanium goes as the best judge that the Supreme Court missed having. And it is my great pleasure to invite you, sir, on behalf of the management of the university, all the teaching faculty and students from this law school as well as other law schools. I am told that there are students from 24 law schools that have come to participate in this Moot. On behalf of all of them, I extend a warm welcome, and ladies and gentlemen, please put your hands together and welcome Mr. Gopal Subramaniam. And the third part, which I want to rush because I don't know what the subject matter is all about. The topic that he has given is constitutionalism and modern government. I know that constitutionalism is a bundle of attitudes and beliefs around which the principle that decides the authority and power of the government. To that extent, I know what constitutionalism is. But to relate that with modern government and other stakeholders involved, it requires a great deal of analysis and research, which anyway, I am not capable of doing, but I thought I will just lay down a context so that I probably would lay down the expectations, hoping that along with the entire audience, I also get enlightened at the end of this lecture. Now, since the topic in it says modern government, rightly so, because government is the critical tool, the instrumentality that exercises this power and authority based on which everybody enjoys, an individual or an institution enjoys their rights. But since it deals with the government, we also know that government deals with a lot of other stakeholders. But we should not be carried away with this impression that constitutionalism is a subject that is meant only for legal scholars. Today, law is becoming an all-pervasive, omnipresent entity that it influences lives of various stakeholders, of which three are very important, the government being the most important entity, second, the judicial establishment itself, the judiciary, thirdly, individuals and institutions. In fact, Dr. B.R. Ambedkar, when the draft constitution was ready as the chairman, once the draft constitution was ready, he delivered a speech. He said that this constitution is so flexible, so strong that it will work at all times in our country, whether there is war, whether there's going to be peace. But if something goes wrong, don't blame it on the constitution. There can never be any wrong in the constitution of our country. And so true his words are. Because today, I am of the opinion that if there is something that is wrong that is happening, it has to be either in the government, or it has to be either in the judiciary, or it has to be in individuals and institutions. Because all three, in my opinion, are falling short of the true ideals of constitutionalism. Government, because it's interpreted constitutionalism as a popular constitutionalism, because they want to do all and harness the entire government apparatus to meet their political aspirations. Judiciary, there is a fine line, not knowing whether it is a judicial responsibility or judicial activism. Very recently, we saw 66A being struck unconstitutional. And on the other extreme, you also have the Supreme Court monitoring how mosquito control program in Kerala needs to be operated, how Ganges needs to be cleaned. So you call it judicial responsibility or judicial activism. Still, there is a very delicate border. And on individuals and institutions, there is democratic constitutionalism. Since democracy is for the people, by the people, and of the people, everybody thinks we have to use this apparatus to probably meet even personal benefits, personal goals, get their personal ends met. So there are three different stakeholders, and today's topic is going to deal with constitutionalism and modern government. With this as the background, I join the members of the audience, very eagerly awaiting to listen to what I believe will be an extraordinary lecture by Mr. Gopal Subramanium. Thank you very much.
Thank you, sir. May I now request our head of the department, Dr. P. Ravisekhar Raju, to present a memento to the guest of honor, Shri Gopal Subramaniam, as a token of our appreciation. I now request our guest of honor, Shri Gopal Subramaniam, sir, to light the Kuttuvilakku and inaugurate this prestigious event. It is my privilege to invite Shri Gopal Subramanium sir to deliver the 11th NANI Palkhivala Memorial Lecture.
Dr. Vaidya Subramanium, Professor Raju, distinguished members of the faculty, and my dear friends who will possibly be upholding the Constitution in the years to come. At the very beginning, I thought that I would indicate a little housekeeping format. And I'm going to break away from the style of an orthodox lecture. I would be using the material which is contained in my lecture, and every now and then, hopefully, I'll have the cordless mic with me. I'm going to provoke you to ask questions so that this lecture is exactly the way Nani Palkhivala would have wanted it. I need to say two things first. I had the great privilege of knowing Nani Palkhivala. I readily agreed to deliver this lecture because it is a debt of honor which I owe him. The legal profession is also a profession which is an amalgam of tradition and individual talent. The second reason is that a very distinguished friend of my late father, Mr. G. Ramaswamy, who has made available his extraordinary collection of books for the benefit of this university, is a very emotional reason that I should be present today. Today, I want you to listen, but also simultaneously verbalize, if possible, your responses as you hear me. Because if we don't have that sense of connection in a collective gathering, the lecture can become a mere ritual. And I do not want this lecture ever to be remembered by any one of you as a ritual, but that there was some kind of awakening which happened in all of us to differing degrees. It is wonderful to praise the lives of great men. They ought to be praised. But I am going to ask you to participate in the journey of greatness yourselves. I want you, each one of you, to put aside your own sense of limitations, beliefs, disbeliefs, the childhood scripts and messages which may have been handed over, and think that your ability to participate in a conversation which is going to be around the most important parts of our life, with freedom, with fearlessness, with integrity, and we all must undertake this exercise. NANI Palkhivala had three important facets. The first, legendary lawyer. You must have read plenty of essays about him. But what stood him apart from others? Actually, many lawyers do believe that they are legendary, even if they are not. But what was that which kept NANI Palkhivala in a different league? I wanted to find out, what is that which motivates this man? What is that which keeps him so restive that even after finishing a case successfully, he is in no frame of mind even to accept congratulations, but quickly walks to the car and is looking for a book to read? What is this person? When lesser mortals win cases, you can see the tremendous sense of triumph, as if we have conquered the whole world. But I found that NANI Palkhivala never did this. There was another thing about him. He usually had read all his papers completely. He was not the specimen of the modern day lawyer, and I say it with some amount of hesitation, who liked to read half the papers and leave the other half, if possible, to words which may float around from the juniors. And they try to put two and two together, and sometimes it looks like a 6. And many judges fall for a 6. But NANI Palkhivala was thorough. He'd finished his reading, he knew his cases, and he had allow for paper-mate pens from the United States because he had a writer's cramp. So he needed to use that paper-mate pen, and he would use it for writing out the written submissions in his own hand. So what would he do if someone was arguing a case? He, in his brief, would have a small book which was hidden. I saw two books. One, the teachings of Dayamata. Two, the essays on Gita by Shri Aurobindo. And to the external person, it would appear that he was actually reading his brief. But I knew that he was reading something else. He had an incessant craving and restiveness which accolades, triumphs, awards, offices, honors didn't satisfy. What was that? He searched for peace in the philosophy of Shri Aurobindo. He undertook retreats in Golconda at the Aurobindo guest house in Pondicherry. Yet, the restiveness continued. And I finally found the cause. The cause was he believed in the values of the Constitution. When you believe in something, we often tend to think that it gives a measure of pleasurable happiness. But if you believe in the Constitution, it will make you restive. It will make you discontented. It will make you disenchanted. And I am going to make you disenchanted today, so that you share what was that which NANI Palkhivala was going through in his quest as a lawyer. And we'll talk about it together. Now, let me tell you that his life is indeed a very interesting life. He came not from an affluent family. He came from a family which needed to support him. He graduated with masters in English literature. And I can tell you that the knowledge of English literature was one of his foundational steps which gave him control over language, over emotion, over communication, and above all, he could feel the depth and intensity of his own feeling. You will have a written script of my lecture, but I am departing from the strict text because we are going to have a conversation. He believed, as Shakespeare said in Hamlet, There are more things in heaven and earth, Horatio, than are dreamt of in your philosophy. For me, Nani Palkhivala was a bow idol. I still remember that when I visited him in Bombay, the Chief Minister of Himachal Pradesh had gifted him a box of fresh apple juice cartons. And he and I, gleefully, like children, sipped a few of them. He was childlike, unassuming, in spite of knowing so much, in spite of having accomplished so much. That gave me the second insight about Nani Palkhivala, which is there is no point of satisfaction at all. If you want to be a constitutional lawyer, if you want to be a student of the law, if you want to be an advocate in the classical sense, you have no room for satisfaction, for belief that work is all done. Work is actually not done. And even when somebody attempts to do some work, there is someone else who gets it undone. I need to tell you another thing about Nani Palkhivala. He had something very common with another figure who was another bow idol of mine, called Bijan Kumar Mukherjee, a former Chief Justice of India. And they both had very similar characteristics of self-effacement. They were the masters of attentive silence. Do we listen actually to somebody fully? In fact, before the first word is said, we have a little humming sound in our own brain. And by the time a person has even finished half a sentence, we have 3 sentences which are ready in our head. But Bijan Mukherjee and Palkhivala learned this art of attentive silence, which is so important for you as constitutional lawyers, because the Constitution will speak to you verbally and many times in silence. But to acquire the ability to hear in silence, what did they do? Who were their friends, by the way? Who were the friends of Bijan Mukherjee? Who were the friends of Nani Palkhivala? The friends of Bijan Mukherjee were, and you must know, these are persons who didn't begin with successful flourishes in their career on day one. They waited, they waited, they waited, they got tired, they got despondent, they got depressed, but they tried. And what was the turning point? The turning point is both of them sought company of some extraordinary people. Bijan Mukherjee walked into the judge's library in the Calcutta High Court and suddenly found that there were some tomes of Cicero. There were some collections of Dante. There were some collections of commentaries on Indian philosophy by Professor Das Gupta. He started reading them. Simultaneously, he read story on equity. Palkhivala wanted access to a library. So one day he mumbled a request to the secretary of Chief Justice Chagla and said, "Can I meet his lordship for a second?" Chief Justice Chagla recounts about it in glowing terms in his book Roses in December. And Chief Justice Chagla said, "Yes, what would you like?" He said, "Sir, I just need permission to read a few books in the Senate library." And he read and read and read books of philosophers, of authors, of economists, of literatures, of great men who have actually fashioned the Constitution. If one does not read the life of Jefferson or Abraham Lincoln, fortunately, the great film did some justice to Abraham Lincoln. How are we going to understand the pains which precede the birth of a constitution? We must have some idea of pain. And if we don't have at least some room and space for pain, please remember, important areas of public conversation will be lost. We will be deluded by, shall we say, the leaps in economic growth. We will be overtaken by the fashions of the world, and we would be overtaken by, shall we say, the less painful avenues which are always available to us. Both Bijun Mukherjee and Nani Palkhivala had another person, again a Bow idol. I had the privilege of sitting on his lap, Motilal Setalvad. He too was helpless. He said, "What is this profession? I'm getting no brief. Nobody wants to engage me." And it was an evening when he told his father, "I want to be a part-time lecturer in law." And his father just allowed it to pass by. And suddenly, all that reading which he had done for those years in waiting became the great weapons of strength and knowledge. The point I'm making is, to understand the Constitution, we must have undertaken some pain to read our history, to feel our history, to feel with people, to feel with suffering, to identify and empathize with persons who do not have a voice, or who do not have even a knowledge of what something called the Constitution is. And that is how this topic chosen by you for remembering Nani Palkhivala, in my view, is indeed a very extraordinary coincidence. Now, let me go forward. What did Nani Palkhivala think of justice? Because we're going to talk about it today. What is justice? Is it a subjective opinion? Is it an objective opinion? And I must tell you, when I see judges very confident, their chest is upright, and they seem to know that that is justice, there's something in me which says, can one ever be so sure? And I will give you an example of why that thought came to me. When I joined the bar, and mind you, each one of you has the NANI in you, because you can connect to it only when you have it in you. Every one of you has the totality of this potential. And my presence here is just to make a facilitative connection. I met a great judge, A.P. Sen. I was a young lawyer, very shy, very prim and proper. And I remember that I argued a case just before what is called lunch these days. Actually, courts are not meant to have lunch. We usually are supposed to call it only a midday recess. But nowadays, lawyers, judges, everybody says lunch, tea. Well, but courts don't have lunch actually. Judges may have lunch, but courts don't have lunch. But after, just before the midday recess, and we call it the midday recess, and it's a tradition firmly established in the Madras High Court, that you call it only as a midday recess, followed in Calcutta, followed in Bombay, and all over. And sometimes, when I say, may I have the leave to continue after the midday recess, I find that some people are not too sure what am I saying. But anyway, Justice Sen dismissed my petition. And he came back at 2 o'clock. And he said, please send for the gentleman. Now there was a courtmaster. He was a very humorous Bengali, full of life. And you know, there are some courtmasters who feel that they are courtmasters. They're masters of the court, you know. So he said, there are many gentlemen here. Which one did you want? So he said, no. He mentioned my name and I came. He said, Mr. Subramanium, I'm extremely sorry. This case deserved admission. Something struck me in that recess. And I just looked at him, and then later he told me, the most dangerous thing, Gopal, for a judge is even to believe that he knows anything. It's the biggest danger. You have to wipe your slate clean, 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 every time. And he said that is how a judge learns what is called abject humility. Nani Palkhivala had that total humility. He knew the Constitution inside and outside. But if I would sit with him, he would read Article 14 once again with me, as if he was reading it for the second time or the third time, and I knew he knew everything about it. This is a lesson. But let's go forward with Nani's life, and I'm going to take you straight away to the importance of the Constitution, constitutionalism, and modern government. Before that, I had asked a question. What did actually Nani think of justice? And he said this in his tribute to Chief Justice Chagla. To the Romans, justice was a goddess whose symbol was a throne that tempest could not shake, a pulse that passion could not stir, eyes that were blind to any feeling or favor or ill will, and the sword that fell on all offenders with equal certainty and with impartial strength. This goddess brooded over the Chief Justice's court, but her stern features had relented into a compassionate smile. And the language of the statue was sometimes subjected to severe strain when one of the parties before the court was within the rancor, the tramp of the road, the slave with the sack on his shoulders, prigged on with the goad, the man with too weighty a burden, too weary a load. This should give you an idea that the Constitution is a dynamic process. The dynamism of the Constitution, with the same words, is constitutionalism. I have seen three of the greatest performances of Nani Palkhivala, but I can only speak about one of them today. That is the Keshavananda Bharati's case. The true architect of Keshavananda Bharati's case is not the judgment of the Supreme Court. The true architect of Keshavananda Bharati's case, in my view, was the tremendous understanding of constitutional law which Nani Palkhivala brought in that discourse. The first is, what was the issue in Keshavananda Bharati? Because this issue in Keshavananda Bharati is today being reenacted in different settings. Keshavananda Bharati looked very big, but you will have different permutations and combinations of that question in today's world. The question was, can Parliament do what it likes with the Constitution? Can it abrogate fundamental rights? Can it actually say, this whole business of criminal trial, it's a waste of time. People want justice, and they want quick justice. And quick justice? Why not do it like in a film? You all see films, I'm sure. Got him. Come in? Yes. You're sentenced to death. Go. Finished. 32 seconds. Quick justice. But the implications of Keshavananda were not about Article 31C and the right to property. The implications were, can you tear up this constitution just because you have a brute majority? And say, well, we, the people of India, we have decided to actually now have a unique constitution of 11 pages, and what happens to the constitution which existed? And the reason why I'm beginning with this case is that Chief Justice Sikri's judgment in that case, and I beg each one of you, it's the best judgment in that case. It looks simply written, but when a judgment is simply written and more readable, please take it that the quality of the judgment is much higher. Ernest Hemingway had a fountain pen, and his whole effort was to make the language so simple, so simple, so simple that he had multiple drafts of a book. Whereas the trend is continue dictating. If a comma creeps in, it's your good luck. If a full stop is there, it's your good luck. And if there is a paragraph, it's still your good luck. If it's a page, it's a good luck. And after all, it is the job of SEC to deal with it, not us. But in Keshavananda Bharati, Sikri said these are grave constitutional issues. But he said we would have to apply the principles of the Constitution to decide this issue, however grave they may be. And it is in this context that Chief Justice Sikri said, a constitution has history. A constitution has aspirations. A constitution recognizes pluralistic society. A constitution recognizes diversity of beliefs, conviction, freedom of conscience, faith. We, therefore, will have to bear in mind that the world is not a crystal, transparent and unchanged. It is the skin of living thought and may vary greatly in color and content according to the circumstances and the time in which it is used. That is how the preamble to the Constitution became the most important document to interpret the Constitution. Everybody said, oh, preamble. What is a preamble? Preamble is like, one of those long titles. What is a preamble? You've got acts of legislature which have a preamble. But no. In the preamble were the most critical words, and I want to tell you that even a few of those words were sufficient for the purpose of the basic structure theory. The first was, of course, sovereign, democratic, republic. If it is democracy, you can't have state tyranny. If it is republic, it means freedom of thought and multifariousness. And, in fact, Lord Woolf, who always felt that how lucky are these Indians. They have a written constitution. But he said common law was based on Magna Carta, and Magna Carta meant a Bill of Rights, and a Bill of Rights, therefore, must have meant a constitution. And he said, well, even if you just have the word democracy, it's enough. It means that there is a Bill of Rights. You will get to read about that in one of his lectures called the Ban Lectures, which I've referred to in the text. And he was asked a question, just like what I said a little while ago. Why have these courts? And by the way, between you and me, the number of courts is decreasing in the name of what is called specialization, domain expertise. I'm going to make some fun of it, so I'm giving you a heads on. Now, Wolf said that what happens if Parliament did away with courts? He said, if Parliament did the unthinkable, then I would say, and mind you, unwritten constitution, the courts would also be required to act in a manner which would be without precedent. Some judges might choose to do so by saying that it was an irrebuttable presumption that Parliament could never intend such a result. I myself would consider that there are advantages in making it clear. Then ultimately, where are even limits of the supremacy of Parliament, which it is the court's inalienable responsibility to identify and uphold? They are the limits of the most modest dimensions, which I believe any Democrat would accept. Later, he said, parliamentary democracy, it means the rule of law. And the supremacy of Parliament is necessarily subject to judicial review. But Chief Justice Shri took word by word every part of the preamble and said, wait a minute. If we, the people of India, have said we are a democracy, tomorrow, are we actually going to abolish democracy? If we, the people of India, are saying there should be justice, are we going to abolish justice? Actually, why use the word justice? Why not coin some other word? Nowadays, modern words have modern meanings. So why should I use this word justice? Only if this word justice existed in the preamble, you have all this trouble of courts, you have all this trouble relating to judicial review, and then you have these arguments about judicial activism, overreach, and somebody trying to say, no, it is necessary. We'll come to that also a little later. But it is when Chief Justice Shri looked at the preamble, the liberty of thought and expression, belief, faith and worship, equality of status, and a word which is not very often understood, fraternity. It struck Justice Shri, this means something. This means a social order which has to be assured by the Constitution. And that is how he began relying upon the preamble, and he dissented from the previous opinions of the Supreme Court, which said preamble is not a part of the Constitution. This was the first big contribution which Palkhivala made in that argument. The second was, there was a Ceylonese case called Ranasinghe's case. And in Ranasinghe's case, again there was a provision called Section 29(4) of the Ceylon Order in Council, which enabled the entire constitution of Ceylon to be washed away. And what they did was, I spoke of Gotham's coat, right? In Ceylon, they said, why have these judges, they don't know how to deal with cases. Let's have a new court, bribery court. Bribery court? Bribery court. No question of this judicial independence, freedom from political control. My God, we talk so much about judicial independence, freedom from political control. Just wait for a few more minutes before we get there. But it is Ranasinghe's case which again Palkhivala astutely analyzed before the court and said, the Privy Council struck it down because it was repugnant to the idea that there must exist a constitution to govern. Can you be in a state of anarchy? Well, sometimes when, if you read Ayn Rand at say about 11:30 in the night, you could feel a bit anarchic yourself. But usually in the morning you still feel better. But we can't ascribe to Ayn Rand the Constitution. But this important understanding that there is an immutability about fundamental pillars of the Constitution which are in these ideals, and we're not talking about ideals in the sense ideals like a something in the sky. This word ideal is actually a very misunderstood word, because the moment you say it's an ideal, it means it's an ideal. It belongs to the idea. People actually like to use, nowadays at least, the word reality. Reality has got a lot of pugnacious flavor, and also use the word focus. Well, I find it difficult to deal with reality as it is, but to deal with it with focus is still more difficult. But I'm just telling you that the ideals which Keshavananda spoke about and which Palkhivala advocated were in the context of what must be the freedom from political control. Remember, this is a very important point, and this is where we are getting to. What do we mean by freedom from political control? Suppose Dr. Vaidya Subramaniam is told tomorrow that, don't please ever read that book. Can you give me that book if you don't mind? Called Administrative Law by Schwartz. It's written, by a foreign author. We want administrative law written by Indian authors. And Dr. Vaidya Subramaniam, please don't teach your children administrative law with reference to this Schwartz. Unfortunately, we don't have too many books by Indian authors. And a couple of good ones, they've died. So, Schwartz, I picked up this book because G. Ramaswamy, the brilliant lawyer, did not only own a great library, but he also read the books in his library. Because we are great show-offs, particularly lawyers, and we always like to sit with books behind us. But I still remember I was appearing with G. Ramaswamy as his junior, and a question came about quality of an administrative act, and he just rubbed his forehead. Whenever he was about to get an answer, he would rub his forehead. And he said, yes, 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 there is a book. It is in Schwartz. He looked at me. I said, edition? I have the latest edition, just get it. And do you know, this book won the case called Union of India versus Cyanamide, where Mr. G. Ramaswamy and I both appeared. He was such a brilliant lawyer. He read his books. And if suppose someone says, no, why do you want to actually prescribe now? Sorry, I hope it didn't hurt you. Why do you want to prescribe books by H.M. Seervai? He writes such long sentences and he quotes Wordsworth every time. And when he's fed up of Wordsworth, he quotes Coleridge. We don't want that. We would like instead, I don't know what is the equivalent in your university, but in the north, it has actually a colloquial name. Why don't you prescribe dukis? Have you heard of the word duki here, anyone? Are there people from the many law colleges who have heard of something called a duki, which is a short booklet? Very easy to handle. You can even put it inside your trouser pocket and provides requisite answers to questions. And many people have claimed to pass exams with the help of those. What happens if tomorrow the government were to say, you know, I'm looking at your syllabus in class 9, you young children, I think you all need a holiday. Holiday? The children don't mind a holiday, but what happened? We think that, you see, your science books are not exactly telling us clearly where Mars is located. So we would like to first make a journey to Mars and then come and write a fresh science book. Political control is the most dangerous thing in society. And it can be achieved in multiple ways. Multiple ways. Law is only one of them. But science law, there are so many ways you can achieve it. Look at it. Freedom from political control. That is the quintessence of Keshavananda Bharati. Why was an independent judiciary a part of the basic structure? Freedom from political control. What is freedom from political control? What is freedom from political control? You're not supposed to actually do what the political executive wants. And I request each one of you to look at, because all of you have Wi-Fi enabled university here. I used actually your Wi-Fi. And please do go to the YouTube, and I want you to go to a BBC4 commentary called the UK Supreme Court. If you go to that link, you will find that Lord Hope, one of the great judges I've met, he said, our job is not to please people who are politicians. I mean, it's as simple as that to us. We are here to interpret the law. And we may be completely on the opposite sides of the fence. But that is what the rule of law is all about. That is what law is about. That is what an independent judiciary means. That is the quintessence of an independent judiciary. Well, in order to secure an independent judiciary free from executive control, we had a system called the collegium. Now, I must tell you, this word collegium, I was partially responsible for using that word. It's actually an ecclesiastical word, but it's okay. And the collegium was supposed to recommend appointments of judges, and therefore everybody had something to say. What is this? In which country does this happen? In which country actually do judges appoint judges? One person said, where is the democratic pedigree of the judiciary? Everybody must be accountable to democracy. Well, I think the Supreme Court actually had a very tough time taking a view at that point, because in reality, and now let's talk about reality. What is the reality? If you are a party worker of a political party in government, and it comes to power, and you happen to have a law degree, and you are a lawyer, then you feel that there is a legitimate expectation, that your services must be recognized for the advancement of the cause of justice, and you must at least, if not anything else, be considered for appointment as a judge. And if you have another political party which comes in between, they would say, wait a minute, what about our men? But in order to prevent executive veto in judicial appointments, judges formed this idea of collegium. But one must say, the collegium also produced very serious errors. They also are equally responsible for the inroad again being attempted on judicial independence. So how was this inroad attempted? The inroad was attempted by a National Judicial Appointments Commission. And have you ever seen a constitutional amendment signed by the President of India? You must be wondering, should I change my pen? That after signing a constitutional amendment, it says it will come into force on a date which the government will notify in the Gazette. So is the Constitution amended, or is it not amended? Will someone like to tell me, is it amended or is it not amended? Or is it actually hanging by the balance? And what is that balance? A notification. What is a notification? A ministerial act. So, you have a constitution which is amended. Somebody goes to the court and says, sir, this is all outrageous. This is going to be an inroad into the independence of the judiciary. Do you realize it? It's not been brought into force, Suppose it's brought into force at midnight. What happens? And I, speaking for myself, it's my personal opinion, are we to believe that a Supreme Court which delivered Keshavananda Bharati with such firmness didn't know how to deal with a National Judicial Appointments Commission bill challenge? So one day they took it up, and one day the minister said, well, we are not making any appointments until all the cases are decided. I don't know. Perhaps. I think ministers, like lawyers, do have amnesia. So I'm saying lawyers have amnesia. So very quickly he said, well, actually, until we have a notification, the old procedure will continue. And they appointed a judge. I'm nothing against the judge. He's a qualified judge, hardly the point. But are we going to actually look at Constitution and the independence of the judiciary by some sort of, shall we say, weak-kneed, mutual understandings? If you believe that it is invalid, strike it down. If you believe it is valid, uphold it. You surely can do it. You're able to deliver judgments every day. Why can't you deal with this straight? And deal with it. Deal with it firmly. And show that you can interpret the Constitution and that you're not dependent on a notification not being issued. Can you believe that the power of the Supreme Court to appoint judges through the collegium method is because the government is being so gracious that they're not issuing a notification? Where is their moral strength coming? I want to see Keshavananda Bharati's spirit in lawyers and judges. That is a benchmark. And I'm glad we saw one of it recently about section 66A. Of course, the learned judge rightly says that there are far too many vague words, annoying, insulting, etc., etc. Under which clause of Article 19.2 do I find them? But I must say, in a lighter vein, he refers to what is called the marketplace of ideas, following the American judgments. Freedom of expression is a marketplace of ideas, and soon we may have only the ideas of a market. It's a very serious question. The power of the government to be able to obstruct communication or exchange of ideas between people is absolutely untenable. And it's argued in the year where? 2015, and mind you, all our dignitaries go whenever Magna Carta international seminars are held. They all stand together and pose about the Bill of Rights. What about this freedom of speech, my friend? So the Union of India advanced an argument, and don't mind, that argument needs to be stated very clearly. And I like the judge. He said, I reproduce the submissions of the Union of India in verbatim. And then he used an inverted commas, and it continues for a few paragraphs. What was that suggestion of the Union of India? They said, you know, newspapers are not bad. Cinema? Not bad. Yeah, decent things, you know. There's no question of any offense. There's no question of any freedom of speech being abused. They have institutionalized mechanisms. Institutionalized mechanisms? Like pre-censorship board. Pre-censorship board? Yes, they have institutionalized mechanisms. And you see, the infrastructure for a cinema or a television is you need a room. But you see, nowadays you've got this, what is it called? Can I take your phone? You've got a phone, it seems it's at the click of a button. And it can go anywhere in the world. My Lord, it can go beyond even the boundaries of India. What happens to us? Therefore, it should be upheld as a reasonable restriction under Article 19.2. Do you honestly believe that the print media sometimes is not yellow? Have you not seen people's characters vandalized without reason? Have you not seen trial by press in television channels? But no, they're very holy, they're virtuous. But internet, this internet, I don't know what's wrong with this word internet, maybe you should have another word. This internet is likely to cause tremendous confusion. It can lead to incitement. Now look at that word incitement. Now incitement to an offense is also in the penal code. So what is this kind of incitement? And I must tell you that you can sometimes find that painful things are written about you in blogs. Painful, obnoxious. And you would like, if possible, to meet the author of that blog. The only thing is, he calls his name K. Satish Tirunelveli, but there may be no K. Satish in Tirunelveli. But is that the childish reason for actually interfering with free speech? I'm asking you a very simple question. All of you are extraordinarily bright. We have the theory of intelligent design. Chief Justice Mukherjee said in Shri Rahmat's case, I want to make it very clear that our constitution permits even atheistic beliefs. If you are a Darwinian who believes in evolutionary biology, well, it's up to you. But if suppose somebody spoke and wrote about evolutionary psychology, are you going to actually say, wait a minute, this is danger to society, this man is actually going to work at the fabric of society. But if we can't even tolerate ideas, which means we have actually nothing inside us. That is why the judgment of Justice Nariman is indeed one step by which the confidence in the judiciary, what is meant by public confidence in the judiciary, being able to stand up for fundamental freedoms, is a very valuable contribution. It's necessary. But I'm going to deal with two last subjects, and I'm going to now start moving around. And the two are intellectual, but I must do it for the sake of this lecture. One is about judicial activism, which Dr. Vaidya Subramanium mentioned, and judicial deference. Is it judicial deference or is it deference? I don't know, but it's judicial deference. So I wanted to know from where did we get all these debates about activism and deference and so on and so forth. Now in America, you have two beliefs. You have the conservative school of American Supreme Court, embodied by the Rehnquist philosophy, which believes that, look, I'm a judge. I allow the process of democracy to judge what is best for people. I can't substitute my conscience for the conscience of the millions of people who are being represented by their representatives. Now, it looks quite Aristotelian, it looks very Platonic, it looks wonderful, and it's understandable. But what are we talking about? Where you must look at the figures compiled by PRS. I hope PRS is not a menace to society, which compiles about the figures of attendance of politicians and legislatures, and the percentages are appalling. Can you apply Rehnquist theory here? All right. What is therefore? But even in India, many judges believe that we must not interfere with these executive actions. But between you and me, I'm not very certain that it is based on the Aristotelian Rehnquist philosophy. I think, it's much easier to say we don't want to interfere, because when you want to interfere, it takes a lot out of you to interfere. So, we need to study the psychology of our own institutions. Shri CJ is dead. He's gone. Palkhivala, unfortunately, is not with us. But somebody will have to stand up in place of Shri. Somebody will have to be in the place of Palkhivala to be able to say that you cannot walk over the body of the Constitution irrespective of your arrogance, might, power, majority, whatever it be. It's very necessary to understand Nani Palkhivala's contribution in this light. We talk about equality. It's a very lovely word. But do we practice equality? In how many households in India are not children below the age of 14 engaged as domestic servants? And very often those who employ them speak at seminars, on equality and bonded labor and even trafficking. We have to cut this hypocrisy. I'm asking you to be like Palkhivala, because Palkhivala was restive. Why was he restive? He was restive because there was hypocrisy. The hypocrisy in the administration of the Constitution. You swear by the Constitution, but you don't know what it means. Now we come to a slightly different point about disenchantment. Max Weber had a theory of disenchantment. And the theory had a lot to offer. It made all people humble. They realized that your following interpretation of statutes is not enough. You better read a few books on sociology. You better read something about Dalits. Better go home to go and work with a Dalit. Go and speak to a Dalit to know what has happened in his life. You have to speak. Well, Maggie Smith, I think, did that in a film. So I don't see why lawyers and law students can't do it. But we need to engage. And that engagement now must transcend ourselves. We have to forget what we are. We have to look at that we are not. And you have to grab for it. Because in that effort, you are likely to find, as I said, the silences of the Constitution. Last. I felt very happy today when Dr. Subramanium said that the mic disagrees with you, Dr. Subramanium, that the judiciary has lost me, because the mic says, thank God he didn't come. But my professor, Upendra Bakshi, called me Justice Subramaniam. And I told him, somewhat wistfully, that is all I wanted to hear in my life. I think my life's job is done. Whatever I can do for the rest must be for the betterment of the profession. And Bakshi really showed what constitutionalism was. If you read his article between the classic debate between Professor Ghai and also Kirst, that his constitution must be viewed with reference to its literal words and not history and not ideals or ideology. And Bakshi says, this is what is called C1, C2, C3. C1 means the constitution in its historical setting, the pains of birth. C2 means the constitution in the literal sense or constitutional hermeneutics. And the third is C3, which is the ideology. And he says, if you combine C1 plus C2 plus C3, there could be a struggle. Bakshi was a far-sighted thinker. And Sikri did a C1 plus C2 plus C3 in Keshavananda. So for you as lawyers, and I'm using constitution now only as a symbol, epigrammatic. You have to do this with every law you touch. The C1 plus C2 plus C3 and your understanding. And I will only conclude by saying that when Brinda Karat wrote about the figures of the Food Corporation of India, she said there's something wrong, with this NSSO estimates about the minimum price for grain which is to be offered to farmers. It's something, she says, it seems only 3% farmers require it. She said, I don't know, where is this 3% coming from? Then she did a research on the estimates and found everything was, figures is a speciality in India. We love figures. We toss them up, we break them down, and sometimes we say it's zero. But we can do anything with figures. And do you know her article, which was a very important article on food grains and its procurement, found a place only in one national newspaper. One. And that was the Hindu. But I'm sorry to say, it was positioned on the extreme right of the middle page, by which time usually people may not like to actually waste their morning reading about something called food procurement. That is just to tell you, marketplace of ideas. Oh, teeming with marketplace of ideas. How many ideas are actually even allowed to go through? But I have brought to your notice something even more important. We talk about development. We talk about powerful metaphors of growth, and we divorce them in some way from law. And I only wish to say that there are people in this country who still walk on bare feet on the mud-baked soil. And somehow or the other, it does worry me. I see a boy in Bundelkhand, where cows eat shrubs. And this boy, I observe, and I write, and I am now that boy. I live because I am an accident of nature. I live because I am with nature. I grow because something in me makes me grow. I look at some people and wonder, why are they laughing? I turn back and see my mother crying. I walk further. A stone hurts my hardened skin. I only admire the setting sun because it has an orange color. The color which seems to be most soothing, the most promising. It's a color which entrances me in my lack of engagement with reality. I have no compasses. I have limited understanding and can't often add 2 and 2 right. Just as I close my eyes for a brief moment, I hear again a boy who is a neighbor beckoning wildly to me to return. I see that he is furiously waving his hand. I don't know what can go wrong because I never knew what went right. I reach home and I discover that my father is lying on a bare wooden floor. My mother is looking at him impassively, helplessly. She looks at me. I am unable to run to her, either to offer comfort, nor does she seek my hand for help. The friend who beckoned me tells me my mother prevented my father from committing suicide. I don't know what is suicide. I don't know what my mother did. I don't know what my father is to do. I'm unaware. I live. I continue. And I live truly dumb and insensate. But as I try to sleep in the night, I strangely see the waxing moon making different shapes, as if wanting to talk to me. Does someone really want to talk to me? I ask myself if the waxing moon wanted to talk to me. I smile at the moon. I think the moon too has smiled at me. I fall off to sleep. Thank you. Questions? I can go around if you want. Oh, yes. Oh, no, I can move around. Oh, you want? No, I like to move around. So, now I want the most provocative questions. As many as possible. And I promise not to leave the room till I've answered everyone or failed to answer everyone. I'll make an effort. Please, go ahead.
Good evening, sir. I have two questions to ask you. In your journey as a lawyer in the Supreme Court, have you been able to find one enduring thread from the Supreme Court of Keshavananda Bharati and the Supreme Court of Manoj Narula, especially in the light of constitutional morality, which was one of the points of justification for the Delhi High Court judgment on Section 377 of the Indian Penal Code? That is my first question. My second question, sir, is Part 4 of the Constitution of the Directive Principles of State Policy been reduced to a constitutional orphan, or is it part of our jurisprudence today?
You have to give me a big hand because I've succeeded in my lecture. He's proved it. Question number one. I have no hesitation in telling you that the judgment of the Supreme Court on Section 377 is absolutely wrong. But I want to tell you why. I also want to tell you, and don't mind it, that the judgment of the Delhi High Court is equally wrong. The judgment of the Delhi High Court proceeds on the basis that there is something called right to privacy between two adults, and if they are consenting to a certain form of sexual behavior, then there is no question of violation of that by recourse to, shall we say, the policeman getting interested in their behavior. So the judgment of the High Court proceeds upon what is called choice. That is, you have a choice, you exercise that choice, it's a matter of your privacy, it's your business, and why should somebody interfere? The Supreme Court, of course, has said that, well, they've used some presumptions of constitutionality and all that. They've also cited some decisions of 1934. I'm sure you've seen the judgment. Should you have law clerks at all? That's a question. I can't believe that in a judgment of such important issues would you have a head note relating to sexual intercourse between a human being and an animal put in head notes in a judgment. So what is the position which I have? A complete lack of knowledge of, shall I say, fundamental science. And it's such a pity. Such a pity. You have a powerful face. The gentleman who may be 3 steps behind you may not have your moustache at all. Someone is very fair. Someone actually loses the pigment of his skin even before he knows what's happening. The laws of evolution select your DNA so that you can survive. If we don't know even that much in the year 2015, Let's have some crash courses. Your DNA is selected, and mind you, whatever be your intention, however much you can pray, however much you can remonstrate, however much you can deny, however much you can say, you cannot be compelled to act in a manner which is contrary to what is your DNA. There is no choice involved. And that is why the United Kingdom Supreme Court, and we have dealt with it in the Verma Committee report, this particular issue, purely on science, that this is on DNA. A boy is shot. Another boy actually has a stammer because of the fact that at birth there was a certain positioning of his chords. But nature selected him that way because it wants people to survive and does its best to choose them so that they can live. Don't we have this respect for nature? Why do you think sometimes we have children who are born autistic? Did we want them to be born autistic? Did those children want to be born autistic? Did they want? But the selection by nature of what is the best possible it can do to make you live, it wants you to live. And if we don't understand this, so what are we asking? We are asking that a person who has a different kind of genetic makeup, that he must behave differently? Is it possible? And is it not discrimination? Can you compel people to behave when they can't behave that way? Please understand that point. So the judgment of the Delhi High Court, look, I don't mind, they're getting accolades and euphoria, and I mean, I have respect for those judges. But if you ask me as a practitioner of law, as a constitutional lawyer, this matter involved engagement with science. And you have to know, and therefore please be respectful that no two people have the same DNA. Some have a ear for music. So quickly, he's able to actually use his fingers and strum. Because the DNA is like some kind of a carry forward imprint in evolution. So that's the answer to the first question. But a clear answer. No grey answer. But the second question, that was very tough. That our directive principles, what did you say? Are directive principles at all meant to be enforced? Orphans. Well, that's a very good question. Brilliant. My answer is, they didn't have parents in the first place. That's the answer. Brilliant. Go ahead, please.
Good evening, sir. So my question is whether the present National Judicial Appointment Commission involves political control. If yes, then who will control questionable collegium appointments?
Do you think I did a wise thing by coming here? Very tough question. There was a philosopher called Edward Said. He said, who is going to question authority? Will authority question authority? But I don't want to pass off by giving you some abstruse philosopher's quotation. And actually, they're very useful to fill in when you don't know the real reason. The point is, the way in which the collegium has made appointments, it has definitely lost prestige. There was far more at stake for the judiciary, having taken that power away from the executive and not living up to it. Their fault is much higher. Any day, let me tell you, if you ask me that while upholding the Constitution, who is the first person who is charged with the duty to maintain the Constitution and the laws and the freedoms of people? Judiciary, that's the first. Let's talk about executive second. Let's talk about someone else the third. But it's the judiciary. And political control is actually political control. In fact, political control, fortunately in this country, has never been disguised as virtuous control so far. It's so strange that from 1950 to 62, Motilal Setulvad, who was the Attorney General for India, met the Prime Minister, Mr. Jawaharlal Nehru, on 2 days. Can you imagine? An Attorney General for India meeting the Prime Minister of India, Mr. Jawaharlal Nehru, on 2 days. The first was when? The Constitution, when we were born as midnight's children, and the second was the day when he went to give in his resignation, when Jawaharlal Nehru asked him, "What is your age?" What does it mean? Attorneys General were not servants of men. They were servants of law. They were carriers of justice. And what is the situation in the later years? What happened in later years is indescribable. If an Attorney General had stood his ground during the imposition of emergency in 1974, the emergency would not have been imposed. Yes, he may have been chucked out. And do you know, the legal profession is a very lovely profession, because the man who is wanting to support you actually wants you chucked out so that he gets a chance. So, if the Attorney General goes, there's the next lot of people who are all ready to get in. I want to tell you one very interesting thing not known to the world. We had supersession of judges in 1974. Chief Justice Shri, he actually thought that the next man will be, Justice Shellet, and he was sort of getting ready, and he said that, well, where is it? And suddenly he said, he asked his secretary, where is the notification appointing Justice Shellet? He said, sir, it has not yet come, sir. What do you mean it has not come? He's meant to be sworn in. What do you mean saying not come? Then he rang up and he said, sir, we are thinking, sir. He said, thinking? He's meant to be sworn in. I mean, the man couldn't even believe. He said, he's meant to be sworn in. He is the Chief Justice Designate of India. I've recommended him. He has to be sworn in. And 15 minutes later, Chief Justice Shri was informed that the government has decided to appoint Mr. Justice A.N. Ray. But do you know, the government asked A.N. Ray. Number one was not asked because they never wanted to appoint him. You know, it's a very nice thing. When you don't want to appoint a man, you don't have to say anything to him. Maunam Pandita Lakshanam. That is what it is. You don't have to say anything. Second man, you don't have to say anything. Third man, you don't have to say anything. And they then put their bet on Mr. Ray. And Mr. Ray was asked that, well, government has decided to appoint you. as the Chief Justice of India. Now, much to what is believed in the public domain, and that's why I'm requesting you, don't be in a hurry to rush to judgments about people. Think, find out more, because we're all humans and sometimes errors of this kind can take place. He said, but there are 3 senior most judges. What do you mean? Are you superseding them? Do you know what was mentioned? They said, Mr. Ray, we give you a little time to make up your mind. Are you ready to come? Otherwise, Mr. Justice P. Jagan Mohan Reddy is waiting in the Rashtrapati Bhavan to be sworn in as a Chief Justice. That is why A.N. Ray was appointed as a judge. So, brothers, judges, you know, they call themselves brothers. I think this word brother is a little brothers, but very sad, very sad. And political control means you can get any dirt up against anybody not to make him a judge. You forget about me. I was lucky. Thank God I remained a lawyer. But a lawyer in Madurai who is considered by the majority of the bar to be an outstanding lawyer, because he belongs to a minority community and because he happened to help certain orphans by giving donations in the various madrasas, which are also schools, there's something called, Intelligence Bureau. And the Intelligence Bureau called him a terrorist. So that man said, well, the only thing to do is to say, I'm not a terrorist, and thank you very much, I'm not interested in this job. But tell me, how many judges stood up for this judge? How many stood up for this particular judge and say that this is buncombe, we know this man, and you just cannot take recourse to this? They didn't. And that should tell you that the Rehnquist form of judicial deference and deference, shall we say, to the wings of state is 2 different psychological cups of tea. Here it is not based on any philosophy. Here it is, how do I protect myself? Self-preservation. Why should judges get appointments after their retirement? I've always wondered. And you know, there are some who seem to be so perpetually important for public service that they continue term after term after term after term after term. At least one judge continued for 16 long years, by which time many masjids may have been demolished and many temples may have been built. And his report is still not very clear what happened. It's a farce. It's a complete farce. So how do you control the judiciary? Appointment. How do you control it? By giving an appointment after retirement. Oh, we talked about specialization. So you know, this is a wonderful new game. Be careful, Dr. Vaidya Subramaniam. You may no longer be able to go to the Madras High Court. They may decide we should have what's called a University Court of Appeal. And that University Court of Appeal will have some interesting men, just like many regulators have very interesting men. The very idea of specialization as domain expertise has been a ruse adopted in this country to take the jurisdiction away from the courts, palm it off to retired government servants who wear dresses suddenly for the first time like judges at age 62. They don't even have a law degree, by the way. And they feel different. Have you ever seen a face over like that in any country? This is not Bergman who wanted to change his rule. This is government of India doing this to judges. And they're pleased to appointment. They're pleased at being appointed. What for? Why don't you come and teach at Shastra University a couple of times in a year? Why don't you actually come and speak? Why don't you share your ideas? Why don't you think that your life can be absolutely useful? I admire a judge from Madras. The judge is in the Banyan. She's interested in schizophrenia. She's interested in autistic children. She's interested in disabled children. Life can be spent very purposively. You don't have to do this interstate water tribunal, because interstate water tribunals by definition mean waters which flow between two states and which will continue to flow between two states, and in spite of awards will continue to flow between two states, and whose awards will never be implemented, and waters will continue again to flow between two states. I'm waiting for more. Go ahead.
Good evening.
Dr. Subramanium, I must answer the questions today. I'm thrilled. I think there's no greater compliment I can have than people asking me questions. Please. Oh, yes. Oh, my God. I'm wanting the visiting students also to tell. I think they must be also equally robust. You don't have to give away your moot court skills in a hurry. And even if you do, I can make it out. Pardon? No. They're most welcome. Go ahead.
Good evening, sir. You spoke about how in case Swananda, the question was whether Parliament can change anything and everything. So, although Article 13 does give the judiciary the power of judicial review, does it give the judiciary the power to make a set of things or a set of principles eternal? So, why I ask you this is because we've had certain countries that, when they felt the need, have changed their constitution, the whole constitution, and replaced it with other constitutions. When you have a scheme that provides for that, then, but can the judiciary make something eternal and unchangeable? Thank you, my lord.
Oh, my God. Dr. Vaidya Subramaniam, please remember I'm still a lawyer. I can request some people here to fight for me. Okay, brilliant question. The answer to that is constitutional implementation or constitutionalism can be measured. It is measured in countries, in democracies, in Western democracies, Finland. You take any Scandinavian democracy, you take even Germany. Do you know what happened in Germany? You've all read that book by Malcolm Gladwell. I'm sure all of you have. You all look the types, have read lots of things as I see. Malcolm Gladwell, that Blink. Do you remember that line where he says, grandfathers used to betray grandchildren in Germany, and at last the German government decided to make open all the papers for public inspection so that everybody could know who in their family had even betrayed them. It's very important for us to bear in mind that that is a sign of constitutionalism. But if you are thinking, yes, I have this Right to Information Act, very good act. Right to Information Act, well, The authority has considered your request but is unable to actually grant the request and hereby rejects the request. Actually, I don't know. I mean, do computers produce this? Then you go to the appellate authority. I have heard the appellant at great length, without notice and on a day when he was not present. You follow what I mean? And after having considered the merits of his submissions at great length, I find no reason to accept his appeal. So this man then goes to the CIC. The CIC then says, well, why don't you make it available? So the first posture of CIC is, and that man feels at last justice shall triumph. The CIC has said, why are you not making it available? Come next day. Man is happy. At last, they have to come next day. On the next day, when he comes, they say, where is the file? That officer says, sir, हमारे जो सेक्रेटरी हैं वो बीजिंग की एक टूर में कल चले गए थे और वो फाइल भी गलती से उनके साथ चली गई. Then again it comes up. Now the CIC says, we have looked at the contents of the file. It has many notings, some of which are of some kind, others are of some kind, and now we ask the authority to actually separate the lines which are good and the lines which should not be disclosed. Have you heard of such lovely right to information administration? So you go to the High Court. In the High Court, I now find that the questions are different. In the High Court they say, who are you? He said, my Lord, I am a right to information applicant. No, who are you? Lord, I'm a right to information applicant. I'm entitled as a citizen to get some right to information. Why do you want this information? Is there something? There must be something that you want this information. So the whole thing takes another spin. And then it's very sad that we promise freedom of expression and we hack it. And I don't know, if there was a Snowden here, I don't know what would have happened to him. At least one film says that he dyed his hair white, but I don't know what would have happened to him. But the point is, there is an underlying question in what you've asked. Are people who are going to speak up at risk? Let's put that question straight. Let's deal with a more muscled question. Are people who are going to speak up for the Constitution at risk? Can they be attacked? Can they be bulldozed? Can their families be put in pain? Can the police get after them? Can they be pulverized? Can they be terrorized? You want my frank answer? For a lawyer, I'll say, you can't rule it out. Then you can ask me that why should I actually be so bothered? I might also follow, a slightly more convenient path and look at corporate law. Corporate law, you don't have all these things. Corporate law, you go into an air-conditioned building, and corporate law, you do mergers and acquisitions, and then they're de-merged, and they're required again. But anyway, all that. But if you are going to be a lawyer fighting your battle out in the thick, what happens to you? What can happen to you? Yes, there is an element of danger. So, you can ask me what advice. I can't tell you, please keep some PSOs, no. But you have to make yourself mentally very strong And that is something which both Zach Yacoub and Albi Sachs taught me. They said, and it never struck me, that honesty is its own reward. That's the biggest, if I may say so, myth and falsehood in this country. Honesty is its own reward, own virtue. It's like saying, get crucified. It's all right, its own virtue. No. Honesty is not its own reward. You must know the consequences of being honest, and you must know how to be able to anticipate consequences as a part of your legal strategy. And that's very important, and I hope that professors here will teach you that just not enough to be honest. You must know how to protect yourself. Well, it need not be a K9 class, but it should be a forensic class where you know how to protect and insulate yourself. Very good question, I must say. Yes, young gentleman here, you wanted to ask something, I thought. You? I'm looking at you. Yes? Go ahead, ask. I sensed it.
So being a constitutional lawyer, when you talk about equality, I feel that as soon as you enter the profession, the entire sense of equality finishes. The sense of equality finishes. As soon as you enter, a lawyer would demand a fees. There itself the equality finishes, right? If I have a breach of fundamental right, and I go and I approach a lawyer, he would demand a fees. I might be a person who is of that stature that I can have that financial support and I can actually pay. But the other person might not have the same. So don't you think that at the ground rule itself, there is no concept of equality in law, as soon as the lawyers are there?
Great question. Great question. Well, I'll tell you. I thank Professor B.B. Pandey and Professor Rupendra Bakshi. I'm so happy to see you've got a legal aid clinic here. Professor B.B. Pandey and I and two others, we used to go to a court which is called the Beggars' Court. I don't know whether you're from Delhi, but it's called the Beggars' Court. Beggars' Court in Kingsway Camp. What a lovely name. Kingsway Camp, but it's the Beggars' Court. And what is the offense committed by these beggars? That they would stand at the All India Institute of Medical Sciences and stretch out their arms. A police van will come, lift them up, and put them in. They would be taken to a magistrate, judicial magistrate, mind you, who is parked in Lajpat Nagar. हाँ बताओ क्या चाहिए? सर ये 20 लोग आ गए यहाँ पे वैन में. That is 20 people have come here. ठीक है. Remanded. They will be taken to what is called that Beggars' Court. We used to go as students and would file applications for bail for these outrageously innocent people. They were innocent. Many of them had not even begged. But the police had a vested interest in having a certain quota picked up every day, like 20 chahiye aaj, 30, 40, 50. Put them in the bus, take him. And do you know the conditions in which they lived? Let me tell you, I would like history to be rewritten once again, if anybody saw those conditions. So we actually took it up. We filed applications for bail, and on one day, that magistrate said, देखिए मेरे पास कोई टाइम नहीं है, मैं जा रहा हूं अभी. So then, well, I was a fairly hot and an angry man at that time. Fortunately, I mellowed, lots of grey hair. And I said, wait a minute, I think it's your duty to administer justice. And apropos what I said, consequences, plan it out. I plan, to go to the Chief Justice of Delhi High Court and speak a few words about you this evening. Bail application, please give it, sir. But we then went, to the Chief Justice to say, why should these poor children be in jail for 7 days, 14 days? And do you know what was the food they would be given? The food was not served on a plate. The food was thrown on the floor. Independent India. So we marched up to the Chief Justice and he gave us an appointment and he said, well, you're doing very good work. He looked at me, he said, you're doing very good work. I really appreciate. आजकल youngsters ऐसे ही होने चाहिए, बड़े idealistic होने चाहिए. I was thinking, instead of my doing something, why don't you go and meet Mrs. P.S. Binder, who is the member of parliament, in this constituency. I walked out. And we wrote a report of the People's Union of Democratic Rights. And you won't believe, it is after that things changed. But even in the year 2015, as we are hugging President Barack Obama, lovey-dovey, those camps still exist. They exist even today. So, I am asking you to please believe that our reality has considerable hypocrisy. Don't kid yourself in thinking that this is all, everything is okay, everything is okay, everything is hunky-dory. In fact, litigation has been seen by government today as a means of legitimation. Judiciary is a rubber stamp. My judgment has been stamped. If it is stamped, it is stamped, it's final. This is not something in which lawyers should participate. Lawyers are not supposed to legitimate what are grossly obvious violation of human rights. They must not. They have to stand up. And if they don't stand up, let me tell you, it's not a question of you're winning a case or you're making more money. One error by one person in one case in any part of India, take it from me, in constitutionalism, the repercussions are very strong. You don't have to use this, what is called Harry Potter's logic. But in reality, the moment you weaken the constitution in one place, it can get thoroughly weakened. Are you aware that in many parts of Uttar Pradesh, judges issue summons on private complaints when the man's statement has not even been recorded? Wo hai hi nahi, he's not there. And summons are sent. Who brings them to account? Who brings them to account? There was a scam. And in our country, actually this word scam, again we must change the name, because in our country, scams are transient and temporary in character. They usually suffer what is called a very honorable burial. That is the definition of a scam. There was a crisis in Uttar Pradesh, and I had an occasion to look at that. Accountant General's office. Controller and Auditor General, big man. Accountant General, big man. Constitutional authority, Union Public Service Commission. My God. Well, they are constitutional authorities, but they are human beings, and we have got to look at their actions somewhat even more closely than ever before. But I'll tell you about this Accountant General. In UP, very cleverly what they did was, in relation to certain categories of government servants who were class 4, there were no accounts. So any number of withdrawals could take place. That was that Provident Fund scam, which, if you remember, where some people were involved. But actually, that was just the tip of the iceberg. The iceberg was the Accountant General's office is actually a coral reef. Dig in and money will come. Dig in and money will come. I'm afraid in our country the subversion of law has been practiced with greater mastery than NANI Palkhivala. The subversion of truth and justice is really a challenge which we have to meet. But you are all going to meet it. I'm very confident because you all have it in you. You are a modern generation. You're not bound by superstition. You're able to take questions. You're able to take issues head on. You're able to look at things closely. You may differ on some points. We're all entitled to differ. But I think, as lawyers, well, I have never wagered a bet. As you know, betting is illegal. It's contrary to public policy, violative of Section 23 of the Contract Act. But I would definitely like to wager that these young men here will preserve the Constitution.
Sir, referring to your recommendation for the judicial appointment, sir, are you a victim of the modern government or are you an ardent constitutionalist?
Well, I want to tell you, I don't want to feel a victim at all. I don't want to feel a victim. Actually, life teaches you. And I've had a first-class lesson. In terms of money, nobody could have paid money to get the lesson or understand human behavior as I could in those beautiful months. And mind you, I looked at it with dispassion. First-class lesson. And I have absolutely no regrets. And I can tell you, I would have fallen down in my own self-esteem if I did not walk out and be prepared to put it all away. It needs some courage because everybody looks at the future, the prizes of the future, those wonderful, glamorous possibilities of the future. But no, I did it. I've done it before. So it came to me a little more naturally. But I did it consciously. There is a certain opinion that I should have waited for the consultative process to again take a view. But it's up to me whether I want my reputation to be subjected to. I believe in myself so much. If I don't believe in myself so much, I don't want my reputation actually to be second-guessed. No way. And I'm not giving that joy to anybody. Yes, go ahead. Please, go ahead. Don't worry. It's all right. Even if it's one more, it doesn't matter. Yes, certainly.
Good evening, sir.
Welcome.
Article 14 has read down to mean equality amongst equals, though the article per se doesn't talk about it. But I feel that this article has been used as a tool for highest amount of discrimination, by litigants often stating that they don't fit into the people to whom this law applies. Could there ever be guidelines that could be laid down to analyze the sense of equality that exists amongst a set of persons?
I don't know, Dr. Vaidya Subramaniam. I can't believe. What exactly are you teaching these gentlemen and ladies? This is a question of great importance because the perception of inequality, which you're speaking about, is a subjective perception in the first instance. And sometimes, like rumors, if that perception is circulated between people of a certain group or a caste or a denomination, it can pick up fire. And sometimes in our country, we believe in something because we've already said it. But your question had a more scientific content to it. If such feelings of inequality are harbored, is there a way to test them? Can we simply test them on the basis of psychological wrongdoing? Well, if you go by that, everybody can actually play a beautiful drama of being a victim in life. Life has been most unkind, people have been unkind, and the teachers have been unkind, fellows have been well, yes, it's quite possible. But to measure discrimination, we have to find a nexus between power, within quotes, or state, and there must be a close causal connection with you, with your deprivation. That is the scientific test. That scientific test is, does a man get lost out only because of a certain factor like this? It's an important question. And I must tell you that there are sometimes no straightforward lines to be also drawn. I have seen some of the most outstanding students of mine who belong to the marginalized sections of society. I mean, their work, their dedication, their character speak for themselves. But does it mean that such sections never exist? By a few examples, it may be an indicia that the ability to conquer disability has improved, but it needs to be again measured. You see, therefore, in today, again to go back to Max Weber, our lawyers here, judges here, need to be interdisciplinary. I beg of you, I want all these specialized tribunals to go. Just take the Stock Exchange Board of India. It's called what? SEBI or BB? SEBI. Now that SEBI, Stock Exchange Board, Securities Exchange Board. Now the Securities Exchange Board has no judge, you know. And why should there be judges? Not a desirable thing. But they can pass orders of injunction, they can pass orders of damages, they can attach securities, they can sell securities, they can do anything they like, and all jurisdiction of courts is barred. Are courts so cheap? I want to ask you one question. Are courts of judicature, are judges pumpkins? They can't understand what is a security. They can't understand what is a share. A company judge who exercises jurisdiction under the Companies Act used to be a judge of the High Court, even for cancellation of shares. But no, domain expertise. I want to know what is that domain. So, you have some man from the finance ministry, some man from some other ministry, all favorites working their way silently. Actually, a civil servant, one good thing about a lawyer is when he's silent, he can get the best confessions. I want you to please remember it. Practice it sometimes. One civil servant told me, you know how civil servants operate? I said, very, glibly, and with a very, very innocent face, please, I would be very happy to know how do they operate. He said, they are like ants. Oh, they're like ants. He said, they first get into between the socks and the trouser. Then they slowly travel up. And they travel up, travel up, travel up, travel up. And they can't be found where they are, but they achieve their desired purpose. I thought it was of course, it was slightly anthropological in content, but it seemed a very accurate description. Now, these men are going to actually replace courts. Competition Commission. They said, we want competition. We have to see there should be no cartels, pernicious things. So what did they do? Well, I've got to tell you a bit of a joke. Before this Competition Commission Act came, sir, there was what is called the Monopolies Restrictive and Trade Practices Act, 1970. It was headed by Justice J.L. Nain. He was a great judge, former judge of the Bombay High Court. Our Justice Rangarajan, S. Rangarajan, who was a former judge of the Delhi High Court, I want to tell you about Justice Rangarajan. If somebody wants to know about judges and judges, if there was any one judge who deserved to be the Chief Justice of India, I will say it openly, it was Justice S. Rangarajan. But he was a man of such intellectual enormity that people felt so dwarfed by him that they found it safer not to even have him. And after Justice Rangarajan, more people came. Finally, the MRTP Commission was chaired by a person. I'm not going to mention the name, but I'll give a little description. He walked in at 11:30 to the commission, it's meant to be a court, in tennis shoes, and did not wear the proper robes. And lawyers bowed and said, Your Lordship, lawyers have to know that this is to stop. If you don't insist the right thing is being done, you take it from me, the same things will continue. So, SEBI, now Competition Commission, who are they? They're not some people who've just flown in. There was some competition island between Venus and Mars, and NASA's Hubble telescope located them, and they came in suddenly, and they landed in Delhi, and they are the ones who are now sorting out cartels. Actually, many of them, to tell you the truth, they don't even have a degree in economics. They are members of a competition commission. And they pass orders. They can fine you. They can do anything. I'm asking you, what are we, when you talk of institutions, UGC, University Grants Commission, what is this UGC about? I want to know who is this UGC. I want to know whether they have done 3 tablespoonfuls of good work. Only 3 tablespoonfuls. That's not much. If you have a bad cough, you need 3 tablespoonfuls of a mixture. What are these statutory authorities doing? They are compliant with political control. So when you have an atmosphere where either there can be a susceptibility to political control or that there is de facto political control, the rule of law, take it from me, is, don't say it's like a rope of sand, because the rope of sand still has a rope and it has some sand. There's neither a rope nor sand. Go ahead. Please. Yes. Go ahead, please.
Sir, this question is not related to lecture which you gave, but it's in relation to like when people speak about candidates go for election campaign, they say that poverty should be removed, or they give the data that this much was the poverty in that party rule or that. And in seminars also we speak out. Is there any practical solution in coming years, or if you are asked to make recommendation or give the practical solution for government of India, what you will suggest about citizens' role and the different government rules, like judiciary, executive, different organs of the state, what they can do for improving it?
You know, you've hit again upon a very important part of electoral reform, which is making of false statements to induce people to vote. And I think it's a very important question. If false statistics are trotted, they should be disqualified. But I'm afraid our election commission is not the commission which is going to be able to find out whether they are false. If you read the Verma Committee report and you read the admissions of the chief of the election commission, we asked them that, you see, when you have concentration of women as electors in a constituency, why is it that on the last day, just before the deadline, women suddenly are really spurred into activity and they rush into that booth and they cast votes? He said, sir. Yes, sir. He said, sir. Yes, sir. Please tell me. He said, sir. You know, sir. I said, what do I know? Sir, you know, sir. I said, what do I know? He said, they're not women at all. So the point I'm making is we're putting too much faith in all our bodies for too much time. We need to have audit mechanisms, and the best audit only can be law and watchdogs of civil society. But if a watchdog of civil society means that the watchdog's accounts will be audited one morning and the dog can be taken into custody in the evening, and if someone else can be threatened the next morning, then who do you think is going to step forward and form any non-governmental organization? How many Mukesh Sinners do you have? Do you know that man fought bravely, fearlessly, with such courage? At least he upheld the rule of law. I'm not saying who was guilty. Point is, there must be somebody to stand up to do at least the professional duty as a lawyer. But if everybody buckles down, and mind you, there is nothing more beautiful in the legal profession than this word called harmony. That's why all judges say we must have a very harmonious relationship with the bar. The bar also says we must have a very harmonious relationship with you. The net result of that harmony is that don't please ask us, don't trouble us. Don't ask too many questions. You know, there was one young lawyer, brilliant chap, he filed a petition that there was this preamble which contained the word socialist. He said, why don't you get it knocked out? The government of India is hardly socialist. Every morning they are saying we have ceased to be socialist. We believe in market theory. Then why don't you remove the word socialist? Actually, you know, nobody wanted to go into it. So the petition was dismissed. Why was it dismissed? Because it was dismissed. So you have a lot of responsibility. Go ahead.
Between a judge and a lawyer, whose horizon of freedom do you think is wider? Or do you think you could have contributed more to the legal fraternity if you had been elevated as a judge?
Can someone answer that question for me? Yes, I can tell you the answer. Being a judge is very different from being a lawyer. And the first thing in being a judge is, I will have to cancel from my brain all that I've told you today to start with. But that cancellation does not mean that I compromise. It means I look at things with more scrupulousness, accuracy, exactitude, and I may still employ the same values. Well, if you were to ask me that, did you want to write good judgments as a judge? The answer is, that's the only reason why I wanted to become a judge, was to write and to contribute. But it doesn't matter. You can always contribute to law. And also please consider, if I was a judge, I may not be able to come regularly to your universities and give such provocative lectures. Yes, sir. I'll take you on. Yes, sir. Good question. I will tell you that there are two aspects of looking at this matter. The first is, we must not perpetuate an evil beyond a point. Sometimes reminding a man of his caste can be more deleterious to him than his social advancement. I have to tell you this, frankly. But, having said that, we have to have consistent empirical studies, not these census studies. Please forgive me. These census studies, NSSO, they don't do justice to the question you are asking. Namely, are they a part of a marginalized class who still need affirmative action? Are they still? Let me give you one example. The situation of a Dalit in a state like Tamil Nadu may be completely different than a Dalit in Bihar. Even now, caste overtones are quite strong in many parts of this country. But at the same time, as I say, there is something which is missing, which is not solving this problem, which I believe is that the state has singularly failed in its responsibility. The job of the state was not simply to give quota, 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 quota. The job of the state was to create educational institutions where they would be integrated as parts of society before they come to the level when we are thinking of a quota. Have we done that? You must look at primary schools. Oh, that's hilarious in Bihar. They have primary schools. Well, one is called Madhyamik Shiksha Sangh, another is called Uchcha Madhyamik Shiksha Sangh. There's a third one called Sarvochcha Madhyamik Shiksha Sangh. But anyway, but I found that I studied the population of Bihar, and I found, how is it that they have 27,000 primary school teachers? 27,000 is a lot, you know. And where are they teaching? Who are they? Are institutions which once upon a time were the best institutions for education. I tell you with pride, my grandfather was one of the first headmasters in Tamil Nadu who broke all caste barriers because he believed that schools must be set up. He was a member of the Senate of the Madras University, and it was his passion that people must be taught and must be given an equal opportunity. But you see, it's not enough to have 5 headmasters in succession, after which there are no 3 headmasters but acting headmasters. And after 3 acting headmasters, then we have nothing but fights and cases. You know, let's understand, government today has forgotten that we are human beings. Human beings have a right to ask. What we are told is, keep quiet. That's something which Remington Nariman talks about. Another form of keep quiet under 66A. But I'm on the larger keep quiet. I'm on the larger keep quiet, which is Keshavananda. And that is what Bakshi rightly says, that for C1 plus C2 plus C3, it is the right-centered approach in the Constitution which is paramount. Everything else is subordinate to it. Every human being counts like any other human being in our Constitution. And to give that dignity, to give that opportunity, to facilitate that growth and potential, yes, if you are incompetent and you can't even think on those lines, you can resign. Resignation is only 2 lines. But nobody wants to take that mantle. So we are looking at what? We are looking at investments. I'm asking you a small question. Has anybody invested in education? I also want to know, where do these monies for education go? Where do the monies for education go? In Delhi, I have a municipal school which is just about 1 furlong from my house. I go occasionally to see how many children attend that school. On 7 days in a week, on 1 week I'm telling you, on 5 days, not a single student attended a school. On the other 1 day, 3 students attended a school, but the teacher was missing. So state has a responsibility. Who will ask them to be responsible? Only us. And for that we should be proud of our rights. We should not be at cross purposes with each other. This is very important. I beseech you, irrespective of freedom of thought, differences of opinion, but when you work together for constitutionalism, you have to work together. It must be a very powerful momentum by which governments realize that they cannot trifle with people. You cannot have a person with 4 certificates coming and teaching children. Can you? Although, I don't know Dr. Vaidya Subramaniam. Fortunately, your name is Vaidya, so that means you can cure. I don't know how many doctors even have genuine degrees before they perform a surgery. It is a very serious matter, and it's all because we have not compelled standards. And it is our duty, and mind you, when I say we, I'm also a part of that we. I'm a part of that we. I have failed as much as anyone else. If I were to tell you today, I have written at least 34 letters on why that Medical Council of India must be abolished. Because I said, if doctors come out of these institutions who tomorrow may administer the wrong drug, it's not unknown in this country. You take the left kidney instead of the right, and you find just a 2-line newspaper column. Just a 2-line newspaper column. We have a lot of accountability too, and that can be done only by lawyers. You are gifted for that and you're endowed for it. Why are you endowed? Constitution is that accountability. You know, when I said Palkhivala was restive, and when he gave that payment to Dr. Badrinath for the Shankara Netralaya, he felt that no amount of private charity is still good enough having regard to the suffering of people in our country. It had to come from people within authority and government. There has to be a change. That change is to happen from within. And when it happens from within, consequences will always flow for the better.
Sir, good evening, sir. You did speak on the right to choice.
Yes.
It reminds...
Oh yes, if you wish.
It reminds me of the recent judgment given by the US Supreme Court in Burwell vs. Hobby Lobby. Do you believe that certain principle can be applied in Indian context, especially considering its multicultural society?
Which principle are you thinking of? Can I ask you that?
Right to religion of a closely held corporate, or for that matter an enterprise or an institution.
You see, this right to practice religion is indeed one of the most important fundamental rights. But I think it's also very necessary as constitutional lawyers that the right must not become itself the source of unmitigated harm. And that's a matter of great concern for constitutional lawyers. And that is, let me give you an example. People talk about conversion. They talk about it, they say, well, there should be no conversion. There should be laws against conversion. Well, yes, it looks very nice. It makes a lot of sense. It seems very reasonable, very plausible. Why should anybody be forced to convert? But have you ever thought of a tribal in Khenja, in Orissa, where I have been, where those people are simply boiling the twigs from a tree for their evening stew? And somebody comes and says, if you have fever, well, I mean, whatever it be, and hearkens them to the possibilities of a better life, and he makes a change. What can you do? What can you do? We have charismatic conversions. I mean, nowadays I find that our televisions are the most religious televisions. Actually, the government was right. No, the televisions are virtuous, the newspapers are virtuous. Only internet is a terrible thing. Terrible. Nasty things, you know. Everybody can upload a site. But it is an important question. But the American standards of pluralism are still far behind ours. Far behind ours. Our pluralistic society is the most outstanding society as long as, shall we say, we have little political manipulation and tinkering. The best example is Tamil Nadu. You look at the records of the population in Tamil Nadu, in the various districts in the villages, and you see the level of respect and comity which still is practiced in pluralist sections. I view Tamil Nadu definitely as an outstanding example. But perhaps one of the binding factors in Tamil Nadu was also the language. Language itself can promote its own cultural idiom. And the Tamil language, in my view, is indeed a unifier of its own kind.
Sir, only 9% of the cases which are decided by the Supreme Court are that which involve the Constitution of India and questions which involve important aspects like human rights and fundamental freedoms. My first question is, do you find this a problem that only 9% of the cases disposed by the Supreme Court is actually on the Constitution? And do you think the Supreme Court of India should have the role which is similar to the role of maybe the Supreme Court of the United States, which reserves its time only for important aspects involving the Constitution. Now that you have ruled out mechanisms like tribunals, do you think there is any alternative measures for this?
The first is, I pray that the Supreme Court of India does not become like the Supreme Court of the United States. That's the first answer. The second is, the percentage of 8% which you gave. It is because we have set up these human rights commissions. They have also diluted human rights. You see, have a retired judge anywhere. When he's a judge, he promotes the law. When he retires, he dilutes the law. Maybe I could, it's a good phrase, but that's what happens. So these commissions, so what happens? Instead of courts saying it, they say, why don't you go to the Human Rights Commission? Why don't you go to that man in that place? Why don't you go to that tribunal? In Bihar, you know, they used to say, why don't you go to the collector? Jaiye to, go to him. All right, you go to the collector. My lord, your lordship passed an order on so and so date asking me to go to the collector. The collector has taken no action. No, we will pass another order that you will make a second representation and he will try to dispose it off if possible within 6 weeks. And again, he comes back, my lord, it has not been done. This is very bad on the part of the collector. This time he must pass an order after 10 days. And he dismisses your application. You again go to the court. All right, we'll issue notice. Now we will set aside this order. We will tell him to give you an opportunity and pass a fresh order after 8 weeks. It's a joke. But the point is, I'm addressing your point. Courts of justice have become so oblivious to human rights violations that they are ducking, taking up challenges. If you want to deal with human rights violations, it's dirty work. It will involve investigation. It will involve taking strong position. It may involve awarding exemplary compensation. It may even involve in finding out who are the people, the masters who order massacres. So therefore, like, shall I say, yes, you have human rights violations. It's better we have an opera for human rights violations and a nice piano music when we have the 10th of December, when we have for celebrating the Human Rights Day. Sorry, that 8%, let me tell you, is a very misleading figure. 40% cases involve issues of human rights. You need men who have to take it up. It should be taken up.
So just one secondary question, one secondary clarification. So like when I mentioned tribunals, the main intention behind it was with reference to tribunals which deal with matters other than human rights, so that these matters do not take up the time of the court, of the Supreme Court.
Look, the Supreme Court is not a holy cow. Okay? They're judges. They're paid out of the Consolidated Fund of India. They better work. So should judges of high courts work. So should district judges work. The Constitution intended, under Article 32(3), that every district, in fact, please look at Article 32(3) of the Constitution. Our Constitution makers were wanting a judiciary of such high caliber that they thought that we will have district judges who will be of the quality of Supreme Court judges, so that they will empower by law those district judges to issue writs. Can you imagine what our Constitution thought? So your point is valid. It needs, you see, I'll tell you, we have to embrace burden. Giving justice is embracing burden. Giving justice is not statistics. Giving justice is not pushing people away. It is a very hard choice. I can tell you many judges, they don't sleep well at night because they feel, Have we really, I mean, there's so many cases. Have we done enough? Have we done? Yes, these are the questions. I like judges who feel like this. They should have insomnia occasionally. Lawyers definitely have it.
Thank you, sir.
Very good. Thank you. Thank you.
Okay, before Adit is invited to propose the vote of thanks, a request from my side, sir. After you've almost stood on your legs for 3 hours, and still the audience and the School of Law in particular consider this session as a part-heard matter, and we feel that this is just the beginning of a series of lectures that we look forward from you in this campus. Thank you very much.
Thank you, sir. I now invite Mr. Adit Narayan to deliver the vote of thanks.
Thank you. I hope I did not disappoint.
Respected Mr. Gopal Subramanium, Honorable Vice Chancellor Dr. R. Sethuraman, our beloved head of the department Dr. P. Ravishekhar Raju, faculty members, ladies and gentlemen, we are extremely grateful to Mr. Gopal Subramaniam for having come here in spite of his busy schedule. And modern constitutionalism has always played an important part in the development of our understanding of political and legal environment. In this regard, Mr. Gopal Subramaniam's lecture today has enlightened us with an altogether new perspective on the great source on constitutionalism and modern government. Your gracious presence in today's event is a great source of inspiration for us, sir. And I would also like to thank Dr. S. Vaidya Subramaniam, Dean of Planning and Development, for all his support in making this event a success. And I also thank our beloved HOD for his constant support and encouragement for conducting these kind of lectures in university campus. And to end with, I would like to thank all the participants of the 11th NANI Palkhivala Moot Court competition, as well as my fellow students for being part of this event. Thank you.
I request the audience to rise for the national anthem.
Janagana mana adinayak jaya he Bharata bhagya vidhata Punjab Sindh Gujarat Maratha Dravid Utkal Banga India Himachal Yamuna Ganga Ujjala Jaladi Taranga तव शुभ नामे जाहे तव शुभ आशीष माहे गाये तव जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request the participants to assemble